Hello, everyone. Good afternoon. Thank you for joining us. We just started the webinar now, so we'll let people join the call, and then we'll get going in a couple of minutes. It's great to see so many of you joining us from around the world. We'll give it maybe one more minute for some people to join us, just to let you know that this session is being recorded. Righty ho, I think we'll get going then, everyone. Thank you so much for joining us. I really, really appreciate it. Welcome to UCL and a talk about the LLM program that we offer in the Faculty of Laws. The way this is going to work is that we will start with a talk on a current legal issue, and then you'll have a program overview from the program director, and then there'll be an admissions conversation and a chance for you to ask your questions about the program. Briefly at the start, I'll just ask my colleagues to introduce themselves. If we could just start with Anna, if you could say hi.
Hi, good afternoon, everybody. My name's Anna Donnovan. I'm a corporate lawyer here at the faculty. So I'm an associate professor in corporate law, and I'm also director of our Centre for Ethics and Law.
Thank you very much, Anna. And then Sarah, if you could introduce yourself.
Hello, everybody. Thank you very much for joining us. I hope you'll find our presentations really interesting. I'm the LLM director, so my role is to support students on the LLM program. So should you join the program, I'll be around to meet you on the first day at induction, to support you through the teaching, the assessments, and to wave goodbye to you at graduation. Thanks for joining us.
Thanks, Sarah. And just to say that we also have some students on the LLM who are joining us on this Q&A and webinar, and we also have colleagues from the admissions team who'll be able to answer your questions later on in the session. Just to also remind you that you will be able to submit your questions using the Q&A box you'll find at the bottom of your screen. I would say just hold off for now for putting them in because your questions may be answered by the talks as we go through them. But if you do have anything after those that you would like to ask us, please do submit them using the Q&A box at the bottom of your screen. Okay, let's begin the first of our sessions with an academic talk on a contemporary legal issue from Anna Donnovan. Thank you, Anna.
Thanks, Alex. Very much appreciated. And I think Raphael's kindly loading some slides up. Perfect. Well, welcome everybody. And to reiterate others, thanks for joining us. In our brief time today, I did want to consider a fairly big but very important topic with you, namely, to what extent is corporate law responsible for corporate wrongs? Now, this does reflect the type of questions that you'll be engaging with should you join us for the Masters, because we're not only thinking about what the law is at a postgraduate level, but we're obviously thinking about what the law should be. And in our brief time together as well, you'll see the benefit of adopting an interdisciplinary approach to these kinds of questions, because certainly when we think out the question of corporate responsibility. And we do this a lot in the corporate governance class that I teach. We're drawing on questions of psychology, sometimes neuroscience, to help provide a more rigorous and robust framework in which to think about these very pressing questions and questions that have really been troubling us for some time, which is suggestive of the fact that they don't have particularly easy answers. So when I pose the question like the one we have on the screen, what we're talking about, and it's a controversial one, is to what extent does corporate law itself facilitate unethical or illegal behavior by corporations? And the premise of this question can be seen in the multiple corporate scandals of which we're all aware. We see them in the headlines all the time. And what's striking about many of these is that when the scandal breaks, they often involve individuals who don't have a legal past. In their private life outside of the organization, they're not known to be unethical or in any way making dubious decisions. In fact, quite the contrary. When these scandals break, people who know the individuals involved are shocked. They haven't thought that person was capable of the conduct in question. And so that really does necessitate for us as legal scholars to think about, well, what is it about the organization, about the corporation specifically, that causes, contributes, facilitates, these are all open questions, this change in decision-making dynamic? Why is it that good people do bad things in corporations? We're not concerned as much why bad people do bad things in corporations. That has an easy answer. But why is it that a person who wouldn't steal a chocolate bar from a supermarket gets embroiled in unethical, illegal, sometimes even fatal decision making when they're acting on behalf of a corporation? So if we could go to the next slide, Raphael, that would be fantastic. Because when we think about this kind of big, seemingly abstract question, it's really helpful, I think, to anchor ourselves in an example. Otherwise, we can think, is this a consideration of more mere academic inquiry? But as I've mentioned, what we're talking about here is very real world corporate scandals. And the number on the screen there, 347, reflects very sadly the number of people who died as a result of two Boeing 737 aeroplane crashes. In October 2018, the Lion Air Flight 610 crashed, killing all 189 people on board, and one diver also died as part of the rescue operation. A mere 5 months later, in 2019, Ethiopian Airlines Flight 302 also crashed, killing all 157 passengers and crew. So these are the most fundamental questions we need to be asking with the most fundamental real world impact. And Boeing in particular raises a question that we're touching on today, which is, well, who or what, in the case of the corporation, should be responsible for tragedies like this? And what does that question have to do with company law? So if we could change the slide. The question of who rightly arises after scandals like this. Who is responsible? Who is to blame? And as you can see from the screen there, in Boeing, a number of people were put forward in the aftermath of these tragedies. Was there pilot error? Was there something wrong with the engineering? Is it the CEO? What about other employees within the organization who may have known there was an issue with the plane? Because as we'll see later on today, there was a problem with the plane. Who were these employee bystanders who didn't say anything? Was it the board of directors? And these are really important questions to ask. But what they're doing, hence the other pictures on this slide, is saying, is there a bad apple that we can blame? A bad person who did something wrong, a singular individual? And what we're going to start thinking about today is, do we also need to think about the bigger orchard, the company itself, the legal frameworks that operate around it? Because is there a problem not just with the people or an individual, but with the orchard? So if we swap slides, Raphael, that would be great. Because what we're doing when we're thinking about this apple and orchard question is picking up on what's called the fundamental attribution error in psychology. And that is when something goes wrong, we often focus on dispositional attribution. Is there something to do with the individual themselves, their disposition that caused the problem? Are they greedy? Are they unethical? Are they angry? Whatever it might be, what's wrong with the individual? And that has an important psychological function. It gives us comfort and confidence as an individual that, oh, I would never do something like this because it's a them problem. It's an individual problem. So I don't have to look at myself, which is uncomfortable, and think, what would I have done? Would I have been at risk? But what we're talking about here is saying what we actually need to be doing more of is looking at the orchard, looking at the situational attribution issues that might be causing this phenomenon we talked about a minute ago of good people doing bad things in corporations. What is it about the situation, in this context, the corporation, that might be contributing to these behaviors? Because not only does that allow us to understand the problem better, but of course, a consequence of that is it says what levers can we pull, regulatory, cultural, for example, within an organization, that can help prevent these tragedies happen from moving forward and happening in the future. And one of the values of looking at Boeing as an example is, as we're about to see, there are an awful lot of situational factors in Boeing that did contribute to the disasters that we looked at a moment ago. So if we can change slides, we can first think about the impact that profit and culture had at Boeing. Because to understand what happened in 2018, 2019, we do need to take a step back. Before 1997, Boeing had a strong reputation as an engineering first organization. Engineering excellence was at the heart of what it did, to the point that there was a slogan amongst pilots and other aviation enthusiasts that if it ain't Boeing, I ain't going. It was so well known, it was put on mugs, t-shirts, all this kind of thing. That was the culture of Boeing, which is a very strong driver of behavior. In 1997, Boeing entered into a $13 billion merger with an organization called McDonnell Douglas, which was well known for its defense contracts and also very well known for a financial profit-driven culture, cost cutting, profit maximization, these types of things. And the challenge post-merger was that a lot of the McDonnell executives, including Harry Stonecipher, the CEO, came over to the Boeing organization and took on positions of responsibility. As you can see there, Harry retained position as CEO in Boeing. And they very clearly, and as you can see from the quote on the screen, very deliberately sought to change the culture at Boeing, one that focused on cost cutting. And an example of that is that between 2013 and 2019, Boeing entered into a staggering amount of share buybacks, so $43 billion of share buybacks. And what that is doing in the company is returning money to shareholders rather than investing it into the business itself. And that's just one of many examples that the culture at Boeing had shifted to what we call a shareholder wealth maximizing objective and culture. And that's important when we come and look at company law a bit later on, or some of you who've already studied company law may well be very familiar with. And this cultural shift is important because well-known managerial behavioral scholars will talk about how the famous quote is culture eats strategy for breakfast. The culture are the rules by which we live. That's what drives our own behavior. And so if we go on to the next slide, we can see against that 1997 merger and beyond what happened, what led up to some of the fatal decision making that happened at Boeing. The challenge here was that Airbus released their new plane, the 320neo, and part of the selling point of this was its engine efficiency. And this presented Boeing with a significant decision amidst a huge amount of competitive pressure. Do they start from scratch and design a new plane to compete with the A320neo? Or do they re-engine their existing 737 MAX model, which would be much, much cheaper, much, much quicker? And obviously, that's what they chose, given the cultural framing we were just talking about. The problem that this gave rise to vis-a-vis the 2018 and 19 crashes was this MCAS system that you can see referred to on the screen, the Maneuvering Characteristics Augmentation System, because the new engine required the implementation of this MCAS system. And what Boeing did is it downplayed the significance of that change. And the reason for that is it didn't want to have the plane recertified, go through the regulatory approval process. It didn't want to have to trigger effectively mandatory pilot training, which was again significantly costly and time consuming. The problem, of course, with this is that it meant that when the MCAS failed on those two flights we've been talking about, the pilots weren't aware of what was even wrong, let alone how to respond to it. And we very sadly know what the consequence of that was. So if we change the slide. As I mentioned at the outset, the question of bystanders arose. Why didn't people say anything? And that necessitates the question of, well, what did people know? And you can see the dates of these quotes in 2018, and these are from employees within the organization reflecting on the culture of Boeing at the time, saying, I don't know how to fix these things. It's systemic. That's the nature of culture. It's systemic. It's culture. It's the fact we have a senior leadership team that understand very little about the business and yet are driving us to certain objectives. So they're saying they don't understand the engineering nature of the business, but we are being driven to achieve these profit objectives all the time. And another employee saying quite starkly, would you put your family on a Max simulator trained aircraft? I wouldn't. There are other quotes around the time where people were saying that they have to figure out how to live with what they saw happen. And in one case, they suggested cover up. So we see this culture in Boeing all the time of people being aware of the problems on the ground, but operating in a culture and an environment where they weren't able to, or they didn't feel able to stand up and say something. So if we change the slide, it's important, critically important, when we think about this question as a systemic one, that we recognize, as terrible as these crashes are, that wasn't the end of the Boeing story. You might have seen in recent press over the last few years, here we see an article from 2024, that Boeing's engineering challenges haven't ended there. Most recent issues being doors blowing out, panels blowing out on the airplanes. So even after suffering the worst tragedies you can imagine, we see these issues carry on, which again, as scholars, it has to force us to think about, well, what's happening here? These are individuals who simply wouldn't sign off on these kinds of risks in their personal life. Why is this happening repeatedly when acting on behalf of an organization? So if we change the slide, it means we need to go back to basics with company law and think about how this might interact with the questions we're looking at. By way of very brief overview, and I'm sure some of you are familiar with this again if you've studied company law, we know that there are certain fundamental principles of companies which make them so brilliant because they are brilliant, and this is the challenge. We need to protect these features but also mitigate their harm. We know that a company has separate personality. It's a separate entity in the eyes of the law. That's the square box that we see on the screen. And it means that they are governed by a board of directors. Those are the people on the inside of the box. And they receive capital from shareholders. Those are the people on the outside of the box. Those shareholders have limited liability, Section 3 of the Companies Act. Those are the little arrows. So our shareholders' liability is limited to the amount left unpaid on their shares. And as you can see from the arrow, those shareholders, if they're unhappy, can quite easily sell their shares to exit the company. So that's what Hirschman talks about, exit over voice. It makes much more sense for us shareholders just to sell their shares and leave if they're unhappy, rather than exercise some of the rights they have under company law to try and monitor the board a bit more effectively. Why are these relevant for our conversation today? Well, it makes individual liability very difficult, either for directors or for shareholders. We see time and time again that after a scandal, there is very rarely an individual prosecution. And that lack of liability can lead to moral hazard, people taking high risk decisions because they're not going to feel the consequence of those decisions. And why might they take those high risk decisions? Well, in a company, we know that this separate personality creates this almost singular purpose in a company. What's the objective of the company? For reasons we'll come on to, often that objective is shareholder wealth maximization, make as much money as possible. And so already we start to see that we have a singular driving force when making decisions in a company. So although we've got all of these people in an organization with all of their differences in cognitive diversity, actually they can all often be working just to the same singular purpose, profit, which is very powerful when we combine that understanding with other various forms of psychological knowledge. Because what also happens within the firm, and those of you who might have read Coase's famous work, Nature of the Firm, will be familiar with this, is inside a company, we have a hierarchy of people. We've got the board of directors, the senior managers, and the employees who work beneath them. And that hierarchy can have very powerful impacts on people's behavior. If you're being told what to do, and Stanley Milgram talked about this in his famous experiment, you can occupy what's known as an agentic state. You simply become an agent. You're telling me what to do, and I'm going to do it without thinking about the broader ramifications in the same way that I would if I was acting in my own personal life and on my own volition. It also means it creates a sort of comfort of moral outsourcing because you can think, well, look, I'm an employee at this level of the hierarchy. The people further up, they're the ones thinking about, is this the right decision? Is this the wrong decision? And so people can outsource moral responsibility up that chain. We also have another social phenomenon that happens in this context, this notion of group identity and group dynamics. And again, another social psychologist, Tajfel, and others talk about this, that when you become part of a group, an in-group, the language they use, it creates powerful behavioral consequences because you start to become very closely identified with that group. You become very defensive of that group. You reject people who are outside of that group. And all that means is that if we have this culture, like the one that we saw at Boeing coalesce, you start to identify with it, you start to protect it in really very consistent and powerful ways. And all of these things come together, and many more aside that we don't have full time to go through today, to mean that individuals can act on instruction, and more importantly, they can rationalize that behavior. As human beings, we don't deal with cognitive dissonance very well. You know, the phenomenon, if you're acting contrary to your values, you work very hard to reduce that gap. And we do that by rationalizing it. It's okay, someone told me to do it. It's okay, the objective of the firm is profit. It's okay, all of the other companies in my sector are doing this. And so this really starts to work together to supersede any kind of personal values that you might have and that might be affronted, to say the least, by the things that you're being asked to do. So if we change slides, we can start to think about, well, what does company law require in terms of the purpose of the company? And a provision that the company lawyers amongst you will know and love, Section 172 of the Companies Act 2006, perhaps one of the most debated sections at the time when the Act was being debated before it received royal assent. It tells our directors what must they do when they're acting on behalf of the company. And Section 172 says, well, a director of a company must act in the way they consider in good faith, but most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard to these statutory factors, more holistic considerations, community, reputation, so on and so forth. But as you may know, the primary duty in this section is clear: promote the success of the company. That has been interpreted to mean long-term increase in value, unless the shareholders tell us otherwise, also known as profit. The duty with regard to these broader considerations is simply to have regard to them. You don't need to act on them once you've had regard to them. So we have a legal requirement that says long-term increase in value. And again, those of you who are familiar with this area of law will know that actually gives our directors a very broad brush that they can consider within long-term increase in value. But when we layer on top of that, well, it's the shareholders who have powerful rights over the board. Under Section 168 of the Companies Act, it's the shareholders who can remove directors if they want. It's the shareholders who will be investing capital in the company. It's the share price that will be dictating whether the company is seen as successful in the market or not. And so we have this legal duty shareholder wealth maximization, which, whilst broad, is then combined with market and commercial pressures, which really focuses the board's mind on earnings per share as a key metric, profit, financial value. And this is exactly really what happened in the Boeing situation. So if we change the slide, it brings us to this important question of, well, taking these factors into account, did the law fail when we look at situations like Boeing, situations like the scandals we see every day? In Boeing specifically, there was some regulatory challenges as well. The Federal Aviation Authority had delegated certification ability to Boeing, so that gave Boeing itself a great deal of authority over its own regulatory standing. But whilst that was very clearly an oversight failure, what was the underlying drive that, given the clear risk of failure when your business is aeroplanes, what made individuals themselves decide to abuse that right, if you will? And we've been talking about company law and its role in all that. So, this notion of a single identity. We are the company. We have this singular profit maximizing focus. There's an internal hierarchy of control backed by commercial sanctions and self-interest, promotions, pay, and all of these things that really supersedes any kind of individual integrity or decision making that the employees of Boeing might have had. And that leads us to the question of, well, if everyone was acting rationally within the system that is the corporation, is corporate architecture part of the problem? And so if we go on to our next slide, we can really think about and return to that question of, well, is corporate law responsible for corporate wrongs? Now, we've obviously gone through a very, very quick canter through some of these very complex issues and a lot of psychology and a lot of regulatory design and all of these kinds of questions we would ask around this. But hopefully it surfaced some of the questions and approaches you might take to these really, really complex issues. What is company law for? What is corporate governance for? Who should it be protecting? Shareholders and utility maximization arguments or broader stakeholders? What realistically can company law achieve? We've been talking about how it might be contributing to these questions, but is it a company law solution or should we be looking elsewhere for the solution? And if we do look elsewhere, what does that say about the expressive function of law? Cass Sunstein talks about that. The law tells us what's normatively right and wrong. So how do we want to encapsulate that? What happens when rules of law, like company law, meets rules of behavior, psychology, and neuroscience? And how does structure and regulatory design influence human decision making? We've seen briefly Section 172 on the screen. Could that have been worded differently? And if so, what would the impact be? And when is it legitimate for the state to intervene? Commonly, the company is being viewed as a subject of private ordering. It's not for the state to overly intervene in corporate law matters. And there's increasing movement around questioning that public-private divide when it comes to corporations, particularly given what we've seen today, that these aren't simply academic questions to ponder. They raise serious real world and sometimes fatal consequences. So if we go to, I think, our last slide, unless there isn't a last one, no, I didn't know if I'd put a concluding slide, but bringing that all together, then hopefully that's shown how questions that you'll be considering at postgraduate level will pick up these thorny and difficult challenges, be looking at how we should be thinking about law, the impact that the law has on everybody, and how can we bring our own voice and our own rigor and critical thinking to that debate to try and illuminate this area of not only significant academic importance, but significant real world impact as well. So thank you very much for your time today.
Thank you very much, Anna. That was fascinating. I hope everyone who participated or is listening found that useful as well. If you have any questions at all about the content or any of the issues raised, we've got a couple of minutes now and a space to answer those. If you'd like to put those in the Q&A, we've got a couple of minutes where we can take those. Don't worry if you don't as well. There's plenty of time to answer that when you come and do the LLM with us at UCL. If none get posted, what we will do is move on to the next section of the session, which will be a program overview about the LLM, admissions, the process, the course, the structure, everything that you would possibly want to know about our program. And that will be led by Sarah. So thank you, Sarah.
Thank you very much, Alex. I'm delighted to talk to you about the LLM. I'm very proud of being the LLM Program Director. Before I speak, I'm going to hopefully share my slides. Alex, can you see my
I
slides?
can indeed. You're good to go.
Actually, thank you. So, as I said, I'm Sarah Campling, I'm the Programme Director. Here is a lovely picture of the portico on the main campus. Should you join us at UCL, this is where the main campus, where you will be perhaps taught, although you may be taught in Bentham House, which is the home of UCL Laws. We'll come back to that in a moment. So my role is to support you throughout the programme. And I'm going to talk to you about how I'm going to do that. But firstly, I'm going to talk to you about why you should come and study with us. If I can change my slide, which I will do now. Oops. So why study a Master of Laws or an LLM? Many students see this as a stepping stone for career progression. Some of you may not yet be qualified, but may be intending to qualify as a solicitor or a barrister or in your own jurisdiction. However, some people who apply to the course will already be qualified. And regardless, you're probably going to want to study a Master of Laws because you've done compulsory subjects at undergraduate, your undergraduate degree, and you want to develop your expertise and specialise in a particular area of law, whether it be human rights, intellectual property, company law, as my colleague Anna Donnovan has been speaking about. The LLM is a perfect way to gold plate your undergraduate degree and develop specialisations. It may be that you want to do policy or government or regulatory work. You may not want to be a solicitor or a barrister or to practice. Again, the Master of Laws is a really good way to do that. Some of you may want to go on to become an academic, and therefore you may want to see your LLM as a stepping stone to prepare for studying for a PhD. So here's the picture of Bentham House, which is the home of UCL Laws. It's at the heart of legal London. It's an amazing building in the middle of London. So if you're thinking of studying for an LLM in London, this is a great opportunity to do so because we have access to the other organisations in London, whether they be courts, barristers' chambers, and of course, the people that work in the courts, the barristers' chambers, the leading law firms, come into UCL Laws to give talks and to sometimes contribute to the teaching. The teaching is done by world-leading academics and practitioners. I would suggest that you have a look at the website to look at the background of the people that you will be learning from. Also, we're very proud of our positions in the league tables. You can see some of these on my slide, and also you'll see we're proud to have been told recently that we've now been ranked third in the new QS European University rankings. You can read all about that on the website. This is inside Bentham House, where you'll find a student hub, a cafe, a moot court to practice your advocacy, a common room to practice your table tennis, some of the teaching rooms and some of the lecture theatres of UCL. But of course, you may also be taught in the main campus or one of the other buildings in the university. So why study at UCL? Well, the main reason is because of our fabulous academics who teach a very wide range of modules. You've seen, Anna, we have very many academics that you can look at their experience and their research interests on the website. As well as having amazing academics, we also have a very diverse group of students. So on the LLM, we have about 400 students, and they come from approximately 60 different countries. So some of them have come straight from university, some have been in practice and want to specialise after being in practice, and some are at the end of their legal careers and want to change their career. You also have the choice of studying for a general LLM or one of our many specialisms, which we'll look at in a moment. As I say, we have a huge range of modules. And if you study the LLM with us, you also get the opportunity to do some of your own research. So you can research and study an area that you're particularly interested in and do that alongside your taught modules. It's a 10-month program rather than a 12-month program. So you finish earlier than students who are studying on 12-month programs. That gives you the opportunity to go and get some work experience during the summer or maybe just to travel. There are a huge range of extracurricular activities that I hope the students will be able to tell you about when you ask them the questions. And we also have a fabulous careers service. So here's the list of our specialisms planned for 2026. You can see those listed on the website. As well as the university itself, as an LLM student, you would be given membership of IELTS, the Institute of Advanced Legal Studies, which is one of the best law libraries in the world, I'm told. You will also be able to study in the UCL Law Library and the Student Centre. And this is a picture of the Student Centre, which is sometimes open for 24 hours, but we don't expect you to study for 24 hours. The LLM programme can be studied either on a full-time basis, which most of our students do, or on a part-time basis over 2 years, or on a flexible basis over 5 years. So if you study the 10-month programme, you will start with a 1-week induction week where we introduce you to the course, introduce you to a personal academic tutor and to each other. So you get lots of opportunities for socialising in that first week to get to know people before you start the taught modules in the second week. So for term 1, those 10 weeks of teaching, term 2, another 10 weeks of teaching, and then term 3 is assessments. And during the same time, during term 1, 2, and 3, you are researching and writing your research essay. So there's the course diagrammatically, a week of induction, term 1 taught modules, term 2 taught modules, term 3 assessment, and all the way through your researching and writing your research essay in an area that you are particularly interested and passionate about, hopefully. So as well as the actual course, there are a whole range of extracurricular activities. My advice is don't try and do them all. There's so many, you'll never be able to do this and study. So if you want to be a researcher and you want to write legal articles, you get the opportunity to apply to edit the Journal of Law and Jurisprudence. If you want some practice at advising clients or campaigning, you could get involved in the Centre for Access to Justice. There's a graduate law society that the students will tell you about in a moment. There's academic legal writing course to support your writing during the LLM. You may want to be a student representative, represent your fellow students in terms of their interests in the faculty. You may want to develop your advocacy skills through mooting. And in the evening in the faculty, there are often lectures and events that you can go to. So our entry requirements are set out on the website. There are both academic requirements and language requirements. The academic requirement is generally an average of 65% across all years of study. But as well as your academic achievements so far, we're also looking to see whether you have motivation, analytical ability, reasoning ability, and good communication skills. So when you're completing the personal statement on the application form, we would like you to deal with these questions, which are set out on the website, because we're looking to see whether you have motivation to study the LLM and whether you have good communication skills. We'd also like you to provide a piece of written work on a topic of interest, on a topic of contemporary relevance in your area of legal interest. This is a short piece of work, so again, we can look at your analytical and reasoning ability and your communication skills. There are a range of scholarships, both from UCL Laws and from UCL generally. You can see the details of the scholarships and the awards on the website. We're very lucky that we have our own careers consultant who provides support to UCL Laws students who are applying for jobs in the legal area. So if you would like to actually see Bentham House and meet with us in real life, we have a in-person open day or open afternoon on the 11th of March. You can find out how to register using the QR code on this slide, or I'm sure you can find out how to register by looking at the website. And you can actually meet with some of us, talk to existing students, and ask your questions about studying the LLM at UCL Laws. So we hope that we can see you there. So we're now going to move over to answer some of your questions on the screen. If we don't have time to answer all of your questions today, then please do contact the Laws Postgraduate Admissions team. They are very helpful and willing to answer all of your questions.
Thank you very much, Sarah.
So thank you.
Thank you. Yes, now we are moving on to the Q&A section of the session. I'd encourage you to get your questions in while you can, because we don't have a huge amount of time. So we'll try and answer as many as we can really quickly now. Just as a really quick opener, as I know that Anna, you have to scoot off before the end of the session. I've been asked to hear from you if you have any recommendations of books or podcasts or news sources that students should read before they start the LLM or consider applying for the LLM even.
Yeah, thank you. And great question. The overarching advice I'd say is don't worry about getting ahead on a subject matter. I'd focus more on thinking like a postgraduate student. So a book I think that's valuable is a rule book for arguments. So a rule book for arguments, that's by Anthony Weston. Read it lightly, and I say that because it gets detailed towards the end, but really to try and get yourself in that mindset of critical thinking, how to build an argument, particularly given that there is going to be a research essay aspect to the masters. Podcasts, I think, are just a great way to get the diversity of awareness and thinking that is really valuable when you're at the next stage of your education. So a really quick way to stay on top of the news is the FT News Briefing podcast. It's under 15 minutes every day. It picks up a couple of stories. It's really accessible. You have a couple of people talking about it, so you get a bit of a narrative. And importantly, they're talking about the implications of that news item. So again, in 12 minutes a day, here or there, you're walking to the tube, you can just stay on top of some really topical issues. For a longer form podcast, and this is quite specific, but I really like Parliament Matters. It's by the Hansard Society in the UK. And obviously, they're talking about what's coming up in Parliament. And again, it gives you an overview of what's Parliament interested in at the moment, what's it dealing with, but it also gives you some insights in the kind of behind the scenes, the wranglings that might be going on. And it's just quite a nice, fun way to think what's on the agenda, think about how politicians might be thinking about issues. And again, getting yourself into the mindset of, well, if some regulation is being debated, what are actually some of the bigger issues that might be influencing that debate, or what might they be thinking about in terms of drafting? So there's a few things that I think would be helpful, but like I say, my big takeaway would be things that help you think critically, things that give you a breadth of interest and awareness of what's going on in the world. And then I think you can't go far wrong.
Thank you so much, Anna. Also, just to rewind really quickly, we do have two LM current students on the call with us, Yuki and Georgios. Would you like to turn your cameras on and maybe just introduce yourself very quickly, in maybe less than a minute, to tell us about um, your application process, how you're enjoying the program, what modules you're studying? Yuki, would you like to go first?
Yeah, thank you so much. Hi everyone, my name is Yuki Bu and I'm now studying in LLM in International Commercial Law and I'm a student representative in LLM now. Uh, Maybe let another student do his introduction.
Thank you, Georgios. And then we also have Vaishnavi afterwards as well.
Thank you, Alex. Hello, everyone. My name is Yorgos. I'm from Greece. I'm currently studying the corporate specialism. I'm taking the private equity module, insolvency and restructuring, cross-border M&A, and corporations finance in the environment. Previously, I studied medical genetics as my undergrad, and then I did the conversion course at the University of Law. And any questions you have about the Graduate Law Society, you can ask me questions about that. Thank you.
Thank you.
Hello everyone, I am Vaishnavi Makne. I'm from India. I'm a student doing my intellectual property law specialism here at UCL. I am the faculty rep also. And this year, I'm also participating in the Oxford IP Law Moot. So any questions that you have regarding the moot or what the extracurriculars are like, or what the role of being a faculty rep is, or what about IP specialism, I would love to answer those questions.
Thank you very much, everyone. Okay, we're going to have to do a whistle-stop tour of some of these questions because we don't have a huge amount of time. The first one on the list is, are there any compulsory modules for the general LLM pathway? And if not, what are the benefits of taking a specialism compared to the general LLM that you could otherwise tailor? Sarah, do you want to answer that one?
Yeah, there's no compulsory modules for the general LLM pathway other than the research essay. So everybody is required to research and write about an area of their own interest. Other than that, you have a free choice of all of the taught modules. A question I'm asked often is, should I take a specialism or should I study the general LLM? Well, the answer is there is no answer. It's up to you. So the general LLM keeps all of your options open. So if you are not 100% sure that you want to be an IP lawyer or a human rights lawyer or a corporate lawyer, then my advice would be to study the general LLM. If potential employers are interested in what you've studied, they will look at the modules that you've studied. But if you decide to opt for a specialism now in, I don't know, into competition law, intellectual property law, whatever it is, then if you're applying for jobs in human rights or something different, then you may need to explain why your specialist LLM is different. So there's no right answer to that question. It's entirely up to you.
Perfect. Thank you, Sarah. Lots of choice is the theme there. Is it possible to do the LLM whilst employed? Sarah?
Can I answer that? I can answer that. No. In fact, we might ask the students about how busy they are at the moment. The LLM, unless you do it as a either part-time course and you're working part-time, or possibly as a flexible student and just do maybe one module a year. So my advice is the LLM is a full-time course. It's very busy, it's very intensive, and you wouldn't be able to study it at the same time as working full-time, particularly in practice where you'll probably be very busy.
Thank you, Sarah. And then just a follow-up to this question as well. Is it better for a recent LLB graduate to pursue a legal career or do an LLM first? I guess maybe we could ask the students why they've chosen to do an LLM, how that fits in there with their career aspirations. Thank you, Vaishnavi.
I actually wanted to pursue, I came right after my undergraduate study of law in India, which was my 5-year BA LLB law course. And I did that because I wanted to enhance my research skills. And undergraduate study of law, I thought did not equip me completely with the quality of research that I was aiming for. And I just wanted to help, again, I wanted to do something related to feminism and patents and research regarding that. That's why I chose the LLM and the specialism.
Thank you very much. Yuki, Georgios?
Yeah, I'm an international student, come from China, and also I come here after I finish my LLB in China. So, because I want to pursue in the international commercial law, I think my undergraduate study is not enough for this goal. So I'm here and want to have some local experience, also study experience here. So that's why I'm here.
Thank you, Georgios.
Yeah, I would say for me, I picked the corporate specialism because I wanted to get a broader understanding of like private equity, for example, or a lot of like more finance concepts that I didn't know before. Because I did a GDL, I didn't even do like a law undergrad. And I wanted to enhance my employability skills, and I think that has helped as I have a couple interviews coming up. So.
Brilliant. Thank you very much. And actually, that's relevant to one of the questions that we've got here about student who is thinking of applying. They're not a law graduate, but they completed the GDL. Sarah, I guess, are they at a disadvantage in the application process at all? And then Georgios, how did your GDL equip you for studying the LLM?
No, you're not at a disadvantage in the application process. All of the applications are considered equally. So we will look at your results for the GDL, but you will not be at a disadvantage. We will also look at your personal statement and your written work, so ensure that they're okay. But no, we treat students with undergraduate degrees and GDLs in pretty much the same fashion. Georgios is a fabulous example. No doubt he can tell you all about it.
Thank you.
Yeah, so definitely not. I think also in terms of like the structure of the GDL, and because you have like all the like condensed material in 1 year instead of 3 years, I think it has actually helped me in terms of like how to study for the LLM, because of just like so much material that I need to learn for like ahead of every lecture, and also like doing applications, doing extracurriculars. I think it has definitely helped. So I think it's actually an advantage rather than a disadvantage, I would say.
Thank you very much. Another question is about the specialisms and modules. How do they work? How many modules do you choose within a specialism? How many do you get to pick outside? Sarah, can you cover that one?
Yeah, in order to qualify for a specialism, you need to study at least 60 credits within that specialism. So if you look on the website underneath each specialism, for example, human rights law, there will be a set of modules. So you need to choose modules that add up to at least 60 credits. So for most specialisms, that's at least one 45 credit module plus one 22.5 credit module, although for some it could be three 22.5 credit modules, but at least 60 credits in that specialism. Other than that, you can choose the remaining credits within the specialism or from the whole host of other modules that we have. So as long as you have 60 within the specialism, then that qualifies you for the specialism. as long as you also write your research essay in an area which is linked to the specialism. So your research essay plus 60 credits worth of taught modules. Thank you.
Thank you very much. Another question. Someone is a current law undergraduate student unsure about whether they should specialize, whether they should go with the general LLM. I guess I'm not sure whether Yuki or Vaishnavi, are you specialized or in the general LLM? And if you have stuck with the general LLM, could you maybe explain about your choice and your reasoning?
Actually, I just transferred, at the beginning of the AI program, and transferred from the general pathway to the specialism. Because when I'm applying for the program, I haven't decided which specialism to choose. And after several months, and after I meet with the professors here, I get to understand that maybe international commercial law is what I'm going to do. So to do this transformation, I pick the required modules, and if I qualify the required module of the specialism, I can transfer from the general to this. Yeah.
Okay, so you're not fixed at the point that you enroll.
Yeah, actually.
And Vaishnavi, which route are you going down?
I actually have a specialism. Mine is an intellectual property law specialism. I was very clear about that, but I am taking copyrights, patents, not trademarks. I am taking gender law in the state because my interest was feminist legal theories. I wanted to research in that area. So while I have a specialism, I'm also looking to research outside of my specialism or something that views my specialism along with feminist legal theories. And if somebody has their research interest in mind, that they're clear about this is what they would want to do, they want to write a dissertation about it perhaps, I would suggest you go for a specialism and then also pick a module that sort of is like a Venn diagram, but is a common goal or pathway regard, which sort of dissipates into your research goal, which mixes two specialisms, or maybe the LLM allows you to do that. So you can have a specialism and pick a module otherwise, so that you can research outside your specialism.
Thank you so much. That's really interesting. Sarah, quick question for you about the written work submission. Could you really quickly outline the key qualities you're looking for in a strong submission?
Again, difficult question because there's such a variety of good written work that we get. But we're trying to analyze your communication skills. So obviously it makes sense for you to write a piece of work that has a good structure, that has a beginning and has an end. We're particularly impressed if you have a question that you're answering or you've got an opinion about something rather than just describing the law as it is. So it's important that it flows, it begins, it ends, and you cover more than one angle relating to the area that you're writing about. So we want to see your analytical and reasoning skills, what your argument is and why you're arguing it, as well as your understanding of the law of the area. And it's nice if you have good referencing.
Thank you very much. One specific question here about the flexi mode. Can you talk really quickly about how that works over the longer period?
So the flexi mode, you study over 5 years. You have to do a total of 180 credits. 45 of those credits are the research essay, which most people do in the final year. And other than that, you can do as many modules as you like each year. So you could, in year 1, for example, do 45 credit, so that your total credits add up to 180. So minus your 45 credit research essay, that's whatever 180 minus 45 is, in terms of credits of taught modules. And you can do them over the 5 years as you wish. You can leave 1 year where you don't do any study at all. You could start with the first year with the 45 credit module, do a 22.5 credit module in the second year, any combination you like over the 5 years. And and the research essay in the final year of study.
Brilliant. Thank you very much, Sarah. I'm really sorry to everyone on the on the webinar if we haven't been able to get to your question. We have to now run out of time to be able to answer them, unfortunately. What I would encourage you to do is if we haven't been able to get to your question, if you would just send us an email or send us a message, we'll be able to respond to you in detail about your particular circumstance or about any of your questions at all. So please do look on our website, find our email, and just get in touch with us. The other thing to remind you about is our open day, which is taking place on the 11th of March here in Bentham House. We would love to see any of you who are able to make it come and see us in person. That would be absolutely fantastic. All that remains is for me to thank all our speakers, to Anna Donnovan, to our students, to Vaishnavi, Yuki, and Georgios, and to Sarah for giving her talk as well. Lastly, please take a look for further information on our website. And we hope to see some of you in your applications and then joining us in September. Thank you very much, everyone, for joining us.
Thank you, Alex. Bye-bye.